Hello, everyone. Today, we are joined by Advocate Vrinda Grover, who fought the legal battle for fact-checking journalist Mohammed Zubair, right from the Magistrates Court to the Supreme Court, and got him bail not just in the existing cases, but also in the future cases, which could be registered against him based on his tweets. Welcome, ma'am. Ma'am, the Supreme Court has given a very powerful order, and the court has granted him bail not just in the existing cases, but also in the future cases which are likely based on the same tweets. And the court has also made an observation that the power of arrest should be exercised very sparingly. And even during the hearing, the court made an oral observation that there seems to be a vicious cycle going on against Zubair, that as soon as he gets bail in one case, he is remanded in another case. And during the hearing, you had used this phrase, evergreening of his custody, that is going on. And the court seems to have accepted that proposition. So, ma'am, do you see a larger significance for the Zubair's order, not just in this case, but in the larger picture as well? Because we see this trend happening across states, across the political spectrum, where FIRs are invoked against people, journalists, and even common citizens for their social media posts criticizing the government. What do you see? What is the message which the Supreme Court seems to be conveying?
I think the Supreme Court, both through the Zubair order, and as we know, we only have the operative part of the order with us. Presently, the judgment is yet to be pronounced. The court, through this, as well as I think many recent judgments, and the judgment of Satinder Singh Antil comes to mind, the court is repeatedly saying that personal liberty is to be treated with the gravity that it deserves, as has been conceptualized in the Constitution, simply because the police is abusing its power, simply because there is a targeting of certain inconvenient voices, voices that refuse to be silenced, voices that are dissenting. The courts should not shy away from exercising their power of enlarging such persons on bail and scrutinizing the material that the police puts forward to see whether there is at all a case put forward. So I think personal liberty has once again been foregrounded. And at the same time, we have been alerted that there is a real possibility of the police actually abusing the power that it has.
Right, ma'am. And but in this case, you had to fight right from the Magistrates Court till the Supreme Court. And probably every person, Zubair had the legal support of a good legal team, but there could be a lot of people who may not be in a position to avail legal aid. And so, and the Supreme Court has repeatedly said, even in the recent case, in the Satinder Kumar Antil case also, the Supreme Court has reiterated that bail is the rule and jail is the exception. But that seems to be not happening at the ground level. People need to knock the doors of the higher courts for bail. And by that time, they have to spend several days as under trials in custody as well. So where do you think, what should be, because we have, the law is very clear, but things seems to be not working at the ground level. Even the magistrates are not taking note of the legal developments. So what do you think should be done to fix this
You're
issue?
absolutely right. See, it's also that Zubair's case was highlighted. We know that there are many people across this country, and it's not only about people who may be, speaking out on social media. There could be activists, there could be human rights defenders, there could be people of marginalized communities who have been arrested for on not very good legal grounds, who then suffer incarceration for years before their cases, they get bail, if at all. So we clearly have a situation, and this is not a new situation now. It's something which I think the Supreme Court has repeatedly has been underlining and underscoring now. It was in 1987, if we recall, that Justice Krishna Iyer said, bail is the rule and jail is an exception. And this has been reiterated in multiple judgments now by the Supreme Court. As I understand as a student of law, the word of the Supreme Court is binding on all courts, all law enforcement agency, and if this is the jurisprudence that the Supreme Court has written, then every court, whether the High Court or the district courts, district judiciary, will ensure that they conform to the jurisprudence that has been enunciated at the Supreme Court. What we do see happening, particularly in cases where there is, and I think we will have to take cognizance of the fact that there is a politicization taking place of certain kinds of cases, and we can't shy away from that reality anymore. So a case where the individual arrested is seen to be anti-establishment, or is seen to be asserting simply free speech. This is not even dissent. This is simply an exercise of free speech, which those in power, may be social, may be political, may not seem to be very comfortable with. In those kind of cases, there is a wariness, particularly at the magistracy level, to grant bail. And that, to my mind, is actually very worrying. It is worrying not only in terms of personal liberty of the individual, who then has to go through the entire appellate process. And as we know that it's not easy to, from different corners of this country to be able to approach the Supreme Court, given that and get an early hearing and a release. Right. It is worrying also that the magistracy must work free of any of these concerns and the cacophony and the various tumble that is created in the socio-political sphere. The magistracy, which is the first line of defense of our civil liberties, must be able to work without any of this in any way intervening in the manner in which judicial verdicts are passed. But that is not what we are observing. And the court is saying that. It's not an observation that I have to make. My experience is very limited. But in the Satinder Kumar Antil case, the court is giving directions and saying this is for the courts. In Arnesh Kumar, in 2014, the court said exactly these things, including to the police. Yet, when you argue matters of procedure, it is very unfortunate that at the magistracy level, an argument based on 41A does not seem to lead to a legal engagement, and is seen as something, oh, this is just a notice, a paper compliance seems to suffice. And the scrutiny, the rigorous judicial scrutiny, and the asking of the question, which has been asked actually by the Supreme Court on many occasions, why arrest? This is the first question that the magistrate must pose to the investigating officer. I don't have to justify whether what the offense is not. They have to make out a case, not just that there is a prima facie case against me, but they have to make out a case saying that they need to arrest me. So the prosecution has to cross many legal thresholds in order to today take curtail anybody's liberty. And I think we need to link this to, what does Article 21 say? Article 21 say my personal liberty can be abridged if it is in accordance with procedure established by law. What is procedure established by law? It must be just, it must be reasonable, it must be fair. Is there a reasonable case made out? And if it is not just a violation of Article 21. I would go so far as to say that in many cases in this country, it amounts to cruel, inhuman, and degrading treatment, where a person is kept in incarceration, which is a violation of the Convention Against Torture. And that is what is happening to our civil liberties today.
Right. So in a recent interview with Justice Deepak Gupta also, Justice Gupta had suggested that there should be a proper training. The magistrate should be inculcated, the feeling should be inculcated in them that they are also doing constitutional functions. But it seems that it's not that they are not aware of the principles and the law. It seems that in some particular cases, especially in high-profile political cases, they seem to be not exercising that powers or abdicating their functions. So do you think there should be some accountability mechanism against the police as well as the judicial officers who are not properly applying their mind?
I would make a distinction between a police officer and a judicial officer in terms of and I wouldn't call it accountability when it comes to a judicial officer, because I think a judicial officer will be exercising discretion. A police officer will have to record very clearly if it is saying, despite a 41A notice, and the reason is not, and this is something that I think the magistracy clearly needs to call out, for the police to write, the accused is not cooperating with the investigation. What does this phrase mean? I don't think a public prosecutor should be permitted to use this phrase while seeking police remand. Please stipulate what that cooperation is. I also enjoy Article 20 rights of right to silence. What does cooperation mean? That you are saying, give me your bank details because you published a tweet. And I say, no, I have a right to privacy. Then is that non-cooperation? No, it's not non-cooperation. It's an assertion of my fundamental right. And that is the scrutiny that is lacking when it comes to, and the police officers are acting with impunity. They're probably acting also. So the senior police officers, not just the investigating officer, under whose supervision this is taking place, I think they need to be called to account. And there is no accountability today of the police. Within the department, it does not take place. We know that for a fact, it's documented. External accountability, will the person who has suffered then actually return to court and start fighting another legal battle? Who is going to do this? These have to be self-executing mechanisms within the system. Don't place the burden on the person who's already suffered at the hands of the misuse and abuse of law. Insofar as the magistracy is concerned, I think they act under superintendents of various high courts, etc. And it is at that level that very clear guidance needs to be given, as well as when orders of this kind are passed, they have their internal review systems which need to take place. Because we do know that there is an appellate court. So if the magistrate, even in this case, if the magistrate does not give bail, we go to the additional sessions judge. And we do know that in Delhi, the additional sessions judge did grant bail. But it is also the question of police remand, which I think is a very central question to personal liberty. And this we have seen in multiple cases now. In all cases, there is a pattern that is growing with electronic evidence in particular. Today, the electronic device, and this has been very well articulated in a US judgment, Riley versus State of California, where the court talks about how this phone actually carries my life and a lot of my private material. But today, if you go in for interrogation, it is standard SOP. Leave your phone. Why should I leave my phone? My phone has nothing to do with this. And if you want my phone, you will have to say for what purpose, what extract do you need of the electronic evidence. On this, the court has yet to lay down the law. And therefore, the police is getting away with actually driving a truck through our right to privacy completely. So I do think these are areas where we need much more conversation within the judiciary, but the manner in which the judiciary is to act independently is something that I would leave really to the high courts and the Supreme Court to ensure.
Because, ma'am, in the Arnesh Kumar case as well, the court has said that if a magistrate is remanding a person, an accused, without proper application of might and without satisfying that the guidelines are complied, there should be a departmental action. And now recently, the Supreme Court has reiterated some guidelines regarding bail and has set a timeline, like the bail has to be disposed of within the set timeline, etc. And if that is not being complied with, don't you think that there should be some mechanism, at least
the mechanism has to be developed by the judiciary for ensuring that those who are performing this role, that they are working in strict compliance with the law, both the statutory law as well as the law laid down by the Supreme Court. It is, and as somebody who does, I think it's a misnomer to think that the magistrate's court is not a very significant court. It is the first line of defense for every person and citizen. And therefore, the kind of attention, both in allocation of resources, not just in holding them accountable, even in allocation of resources. It's very different when you travel out of Delhi, as I do for certain matters. Look at the kind of resource allocation that the magistrate has. After all, the independence of judiciary must also be felt by the judiciary when they are performing a difficult task. And therefore, I think, and then for the review, etc., must take place, but it is something that the High Court needs to ensure.
Right, right. And now, earlier we used to have this trend of the sedition cases being invoked against journalists and people who are voicing dissent, etc. But now the Supreme Court has effectively kept the sedition provision, section 124A in abeyance. And now we see the recent trend of these cases of hurt religious sentiments, and 153A and 295A IPC, they are randomly invoked, and in many cases out of context. Although the law is very clear that there should be a deliberate intention to create disharmony or create a religious insult. But at the stage of FIR, that is not complied with in all cases. And the person has to undergo the entire process of remand and bail application, etc. And by that time, enough damage is done. So what do you think about this recent phenomena of people taking offense or even manufacturing offense and invoking these cases against people who are voicing dissent? And
I think your phrase manufacturing offense is very pertinent here. This is, it's very interesting because we've been living in this country is not a new country. We are now celebrating the 75th year of independence. We've always been a diverse, plural, complex, and a noisy democracy. And noise is good in a democracy, actually. And yet suddenly there seems to be a lot of perceived hurt at anything that is said, particularly with respect to religion. There seems to be that so-and-so mentioned this or so-and-so pointed it out. And this is not an even-handed operation of law. I'm not going to mince my words about this. It's not as though everyone is able to express when they are being targeted. It is an act largely under the guise of a majoritarian rule, where certain kinds of groups of people are allowed to be hurt. No offense is made out. They are feeling a perceived hurt. Some of us don't feel that hurt. That language is not meant to hurt. That language is actually not even causing offense. Leave aside crossing the threshold of inciting hatred, ill will, enmity, etc., or hurting religious sentiments. There is a deliberate strategy to do this. It's not happening on its own. In fact, even in the case of Muhammad Zubair, and I did peruse social media in order to comprehend that what is this, what really are the machinations by which these cases are being lodged and mushroomed. There are people who, for very, very ulterior motives and extraneous reasons, are actually encouraging lodging of such cases. So this is not happening on its own. My experience in this country, representing it's not necessarily to do with majority, minority, religious minority, across the board, a lot of vulnerable and marginalized groups. Getting an FIR lodged in this country is extremely difficult. And one has to, there are many visits to the police station, etc. Often you have to go on for 156(3) before the magistrate. In these cases, it's quite interesting. The police seems to accept the complaint, and without even saying, is a cognizable offense made out, not made out? What is the nature of the complaint? Somebody is generally saying, I don't like this, I don't like that, he said this, he's been saying this forever. And there is an FIR that is lodged, and 14 days police remand. Applications are being moved. This is not a case of zero application of mind. This is a case of malified application of mind by the law enforcement agency. So the manner in which this is working, there is, it would be naive to say that, oh, this is just a few police officers not knowing the law. This is not an ignorance of the law. This is an abuse of the statutory power that is taking place. And here comes the question of accountability. And we know that not just Zubair has suffered incarceration for 23 days. We just heard of Adivasis being released after 5 years. And that's not new in Chhattisgarh or Jharkhand, etc., where for years, the most marginalized groups are incarcerated under anti-terror laws, not granted bail. So now that they are out after 5 years, who is going to compensate them? Not just for loss of liberty. Their lives have been destroyed. We don't know how many of them have been further impoverished. Who is answerable? And I myself have done a study on this, so I know what I'm saying here. There is documented evidence of this. Where is that? Where is the state restituting them what it has knowingly denied and deprived them? And to say that, ask the Adivasi now to go back to the same legal system and seek a remedy there is not acceptable. The burden is on the state. It's the state that now has to compensate them. The state has to punish the officials who lodge these false cases, and these cases are lodged knowingly under the guise of conflict, etc., etc. And so who is failing us today is the state. The state is no longer to be seen as, just either it's not a silent, mute spectator in this entire scenario. The hand of the state can be seen very clearly.
So in cases like this, when the court is properly exercising its powers and granting bail or giving acquittal, it's not just protecting the personal liberty of the accused, but it is serving a larger purpose of preserving the democracy and preserving the right to dissent. And it has a larger manifestation as well. And you would also suggest that there should be a mechanism to review the conduct of police officers when an FIR is quashed by a high court or a Supreme Court, or a person is acquitted. There should be some self-executing mechanism whereby the act of registration of FIR and the conduct of case that is reviewed, so that some accountability can be enforced.
It should absolutely be reviewed. Their promotions, etc., need to be brought to a halt if this is the nature of work that they're doing, as well as I think, so that is the administrative mechanisms, both internal and external, of disciplinary, which for long there has been a conversation in this country and nothing comes of it. And let me give you a small illustration from the by now well-known Hashimpura massacre case, in which the Provincial Armed Constabulary of UP had gunned down in custody, after putting them in a truck in custody, over 40 Muslim men in 1987, a trial a case in which we got conviction only in 2018 by the victim families pursuing the case. I had actually, through an RTI application, taken out the internal documents of the annual confidential reports of the accused through the RTI applications. In those annual confidential reports, what was clear was that the fact that they were being prosecuted for mass murder committed while on duty was not even mentioned in the ACRs, and they got regular promotions. Even as they faced prosecution, they continued to be in service. So that is the state of affairs of internal scrutiny within the police system. Therefore, we need mechanisms like, say, in the UK, where they have independent police complaints authority, which do not comprise of the police itself reviewing their subordinates' work. I think the fundamental shift that I'm trying to argue here, Manu, goes back to the core principle of Chapter 3 of the Constitution. Our entire criminal legal system, and it is partly because it is a colonial statute, and the police functioning is structured also along colonial lines. It views the citizen with suspicion. That needs to be transformed. And that is the transformation that Chapter 3 signals to us. Chapter 3 places the citizen at the heart and puts curbs and checks all along on the power of the state and guarantees freedoms to citizens. What does the police functioning do? What does the criminal law do? If you look at the Indian Penal Code, the smallest chapter of the Indian Penal Code is crimes by public servants. And all crimes are committed by individuals, not by the state. Is that the experience of the last 75 years? I think that there could be a conversation on that. This way of looking at the citizen with suspicion and what the state says, either through its law enforcement agency or through the prosecutor, without any questioning, to be accepted simply because it is the word of the state. I don't think that's what the Constitution says. At least that's not how I read the Constitution.
Okay, ma'am. And ma'am, before concluding, one question slightly off the topic, not an academic question, slightly on a personal note, in your capacity as a lawyer. So this is an everyday battle for you. So Zubair's case, you got relief, but you will be handling several accused cases. And so it's an everyday ongoing battle for you. And in many cases, you will be facing adverse orders from the court, and you're fighting against the mighty state and the police machinery. So how do you sustain your faith and the hope in the legal system? And this is not just a question from me. Many new entrants to the legal profession, they also have this doubt. So how do you keep going without feeling dejected and disillusioned? How do you sustain your faith?
So it's not a question of faith for me. For me, I'm a lawyer. I really don't, at this stage of my life, I don't think I can start doing anything else. But even that aside, it's about, I feel you have to engage with institutions to strengthen institutions. You don't abandon institutions. If I feel that the law, the verdicts, the judicial orders, there has to be, I want to advance an argument that would take the law further, that would take personal liberty further, that would advance rights of accountability of the police, that would create greater rights for women, then how would I do it but through engaging with the system? And I do believe that democracy will be strengthened through our engagement, not by us retreating. I don't believe that one needs to sit back and simply comment and critique and abandon institutions. We have to preserve and strengthen our democracy. The state does not necessarily want to strengthen democracy. Peoples of the country want to strengthen democracy. I want the legal system to be independent, to be attentive both to our constitutional rights as well as perhaps many rights of the more vulnerable and marginalized, which courts are not yet hearing clearly. It is the job of lawyers to advance and espouse those causes. And that's how jurisprudence develops. And that's how law develops. And that really is an engagement. And the hope and strength that I get from is actually from the clients I represent. And I feel as a lawyer, it is not my place to say, oh, what is the point of doing this? If that client, if that individual, if that human rights defender is willing to go forward and fight the battle, the least I can do is to take it forward in legal terms.
Okay. So, ma'am, so you would say that don't be a cynic, don't be skeptical, have faith in your system, engage with the institutions, and fight your battle in a creative and constitutional manner. Thank you so much, ma'am. Thank you.
And bring the change you want to bring.
Right. Okay, thank you so much, ma'am. Thank you for sharing your insights. Thank you so much.
Thank you, Manu.
Thank you.